Okay, let's unpack this. The fallout from the 2020 election, well, it didn't just stay contained to political rallies or, news headlines.
No, it really didn't. It spilled right into the courtrooms, sparking some really intense legal battles.
And today, we're looking at what happens when those claims, the ones made outside the legal system, actually become the subject of lawsuits within that system.
Exactly. And maybe more importantly, how the courts handle the counter-allegations that often follow in these situations.
It's a deep dive into, I guess, the mechanics of the legal system itself when it's faced with these kinds of highly charged claims.
That's right. We're kind of moving beyond what was claimed about the election itself and more into how the legal process evaluates the lawsuits that come later, including, countersuits that claim the original lawsuit was maybe an abuse of the system.
And specifically, we're really zeroing in on the legal skirmish involving Dominion voting systems, focusing on filings related to MyPillow CEO Mike Lindell. We'll be looking at the counterclaims Lindell and MyPillow brought against Dominion and also against Smartmatic and a PR firm.
And then crucially, how Dominion argued those counterclaims should be tossed out, should be dismissed.
So where are we getting this information?
Well, our sources for this are the actual legal filings from the case itself. Also, news reports covering related lawsuits and their outcomes, things like Dominion settlements or jury verdicts in other cases.
Okay.
And just some background information on the areas of law involved, like defamation law, civil procedure, that kind of thing.
So our mission in this deep dive really is to navigate these dense legal arguments, to try and understand the core of Lindell and MyPillow's legal pushback, their counterclaims.
And then how Dominion countered that, how they argue those claims just had no legal legs to stand on based on the material we've reviewed.
It's like peeling back layers, isn't it? Lawsuits challenging other lawsuits.
It really is. So maybe let's set the stage a bit. Dominion Voting Systems initiated lawsuits against various parties, including Mike Lindell and MyPillow.
Right.
And the basis for these lawsuits, according to Dominion, were claims made about the 2020 election.
Mm-hmm. Like what specifically?
Things like allegations that Dominion machines were, quote, built to cheat, that they used algorithms to flip votes, or the idea that the company was involved in the, quote, biggest crime ever committed in election history.
Okay. And Dominion's position was?
Dominion contended these statements weren't just wrong, but that they caused significant damage, real harm to their business and their reputation.
And looking at the broader context from the sources, this wasn't Dominion's only lawsuit, was it?
Oh, definitely not.
Yeah.
They filed numerous lawsuits against others making similar claims. You might remember they reached a very, very significant settlement with Fox News in a separate case.
Right, it was huge.
Yeah. And we also saw mention of related litigation involving a former Dominion executive, Eric Coomer. There was a recent jury finding there that Lindell had defamed him.
So a pattern of legal action from Dominion.
Yes, clearly using the legal system to respond to these types of claims. Now, it's important we include Lindell's perspective here as presented in the sources.
Okay.
He's publicly characterized Dominion's legal actions against him as a campaign of, quote, lawfare.
Lawfare, okay.
Yeah. And we see reports where he describes his own actions as necessary. He's quoted saying he was willing to borrow everything and lose it all to save our country. And he's also attributed negative business impacts MyPillow experienced, like retailers dropping his products, to what he calls cancel culture.
So you really have these deeply entrenched, very opposing views colliding right there in the courtroom.
Absolutely. Which brings us to Lindell and MyPillow's response within the legal process itself.
Right, because they didn't just defend.
No, they went on the offensive. They launched their own legal attack, filing counterclaims against Dominion.
And not just Dominion.
Right. They also brought in Smartmatic, another voting tech company, often mentioned in election claims, and Hamilton Place Strategies, which is Dominion's PR firm.
Okay, so what kind of claims were in this counterattack?
It was a pretty wide range of legal accusations. We're talking about common law torts,
Which are?
basically civil wrongs, things that aren't crimes but can lead to lawsuits for damages. Their list included abuse of process,
Okay.
defamation, claiming Dominion actually defamed them,
Interesting.
tortious interference, alleging interference with MyPillow's business, and civil conspiracy, claiming these companies all worked together illegally.
Wow, okay. That's quite a list already. But they didn't stop there, right?
Now, they went further. They brought claims based on the U.S. Constitution using a law called Section 1983.
And those alleged?
Violations of things like the First Amendment, equal protection, and substantive due process, constitutional rights.
And there was one more.
Yeah, plus a civil IHO claim.
A shy-ho. Like the mob statute.
It stands for Racketeer Influenced and Corrupt Organizations Act. Often associated with organized crime, yes, but it has a civil component, too, that can apply in business disputes.
So a really significant volley of serious allegations thrown back at the companies suing them.
Definitely. Now, the core of the source material we're really digging into here is Dominion's response to these counterclaims.
Right. How did they push back?
Dominion argued to the court that all of Lindell and MyPillow's counterclaims should be dismissed, just thrown out entirely.
On what grounds?
Their fundamental position was that these allegations lacked legal merit. They argued Lindell was basically trying to challenge ordinary activities involved in pursuing a lawsuit, things companies are generally allowed to do.
Okay, this is where it gets really interesting, legally speaking. It shows how the system tries to evaluate these lawfare-type claims. Let's unpack Dominion's arguments for dismissing some of these. Maybe start with abusive process.
Sure. Dominion argued that abusive process isn't just about filing a lawsuit because you have a bad motive or you don't like the person.
It's more specific than that.
Much more specific, according to their filings. The tort of abusive process, they argued, requires an improper use of the legal process after it's already been issued.
Okay, unpack that. What's the difference?
Think of it like this. Filing a lawsuit, even if the motive is questionable, is generally allowed. Access to courts is important.
Right.
But using the tools of the lawsuit, say, issuing a subpoena, or getting a warrant, or filing a lien in a way that's meant to harass someone or extort something totally unrelated to the case, that can be abusive process.
So it's about misusing the court's power once the case is rolling.
Exactly. The sources quote Dominion arguing that the mere filing of a lawsuit isn't enough. The key, they say, lies in the improper use after issuance.
So what did Lindell actually point to as the supposed abuse, and why did Dominion say, nope, that doesn't count?
Well, Dominion argued Lindell's claim was based on things that happened before the lawsuit was even filed, like sending cease and desist letters.
Okay.
And on statements Dominion made to the media about their lawsuit against Lindell.
And Dominion's argument was
that neither sending a warning letter nor talking to the press constitutes a use of judicial process in the specific way the law defines it for an abusive process claim. Those aren't court orders or official court actions being misused.
And the sources mentioned this tort has a restrictive standard. Why is the bar set so high?
Well, the legal system generally wants to protect unfettered access to the courts. You don't want people afraid to file legitimate lawsuits because they might immediately get hit with a countersuit for abusive process just because the other side dislikes their motive.
That makes sense.
Yeah. So the sources note the usual case where abusive process is found often involves some form of extortion, using a legal tool to try and force someone into doing something completely unrelated to the lawsuit itself.
Like using a subpoena not for evidence, but to pressure someone on a different matter.
Something like that, yes.
Yeah.
And Dominion argued that complaining about pre-suit letters or media statements just doesn't fit that pattern or meet that high bar.
Got it. So a clear distinction between filing the suit and actually misusing the court's power within it. Okay, what about Lindell's defamation counterclaim, where he claimed Dominion defamed him?
Right. This brings up a really critical point about what you can and can't sue over within a legal case itself. Dominion's argument was pretty straightforward here.
What was it?
They said Lindell's defamation claim was based entirely on statements Dominion made inside the lawsuit, in their complaint, in other court filings, things like that.
And there's a special rule for that, isn't there? A kind of legal shield.
Absolutely. It's called absolute privilege for judicial proceedings. It's a very strong protection in the law.
Meaning?
It generally means that statements made by a party or their lawyers in a judicial proceeding in court documents during hearings cannot be the basis for a defamation claim, even if those statements are alleged to be false or malicious.
Wow. Even if they're nasty.
Generally, yes. The idea is to allow parties and their lawyers to present their case freely and vigorously within the confines of the courtroom, without the constant fear of being sued for defamation over every single thing they allege in a legal document.
Okay, that makes sense from a practical standpoint for lawyers. You need them to be able to argue the case.
Precisely. It encourages open argument within the litigation process itself.
All right, let's move on to those RICO claims, Racketeer Influence and Corrupt Organizations Act. That sounds really serious. What was Dominion's argument against Lindell's civil RICO claims?
Dominion argued that, generally speaking, RICO claims just cannot be based on ordinary litigation activity, even if you allege that litigation is abusive or maybe lacks merit.
So filing lawsuits isn't usually racketeering.
Typically not, according to their argument. Pursuing a lawsuit, even aggressively, isn't usually the kind of underlying criminal racketeering activity that the RICO statute was originally designed to target.
Okay. And like other complex claims, RICO has specific elements you have to prove, right? What were the key things Dominion said Lindell failed to show?
Yeah, RICO is notoriously complex. Dominion focused on two main elements Lindell needed to prove, according to the sources, the enterprise element and the predicate acts element.
Let's take the enterprise first. What's that?
For RICO, you need to show an ongoing structure, an enterprise of people or companies working together for a common, illicit purpose. Dominion argued Lindell failed to plausibly allege such an enterprise existed.
How so?
Well, specifically, they challenged the idea that a company like Dominion could legally conspire with its own components, like its subsidiaries, or its own law firm, or its PR firm, to form a RICO enterprise.
Why not?
They pointed to something called the intracorporate conspiracy doctrine. It's a legal principle that often says a corporation and its own agents or employees are considered a single legal entity and can't conspire with themselves for certain legal purposes.
Interesting. So Dominion, its lawyers, its PR firm, may be seen as one unit legally.
That was their argument, yes. They also argued there wasn't a believable claim that Smartmatic had actually agreed or acted together with Dominion or the PR firm for a common IFO purpose.
Yeah.
They needed more than just parallel action.
Okay, so the structure, the enterprise, wasn't properly alleged according to Dominion. What about the predicate acts? What are those exactly?
Predicate acts are the specific underlying crimes that form the pattern of racketeering activity needed for any IFO claim. Think of them as the building blocks. Lindell alleged several predicate acts, including extortion, witness tampering, and mail fraud.
You need a pattern of these.
Yes. Typically, you need to show at least 2 predicate acts occurred within a certain time frame to establish a pattern.
So how did Dominion attack Lindell's allegations about those specific acts?
This gets really into the weeds of legal definitions. For extortion, Lindell claimed Dominion was trying to extort silence from him.
Okay.
Dominion argued back that the relevant federal extortion statute requires trying to obtain transferable property, something you can actually give or receive.
Yeah, silence isn't property.
Legally speaking, under that specific statute, Dominion argued silence doesn't fit the definition of transferable property. It's a very technical legal point, but critical for the claim.
Wow. Okay, what about witness tampering?
For that, Dominion noted Lindell's claim seemed to reference a state proceeding something about a Pennsylvania Senate forensic audit.
And the problem was?
Dominion argued the specific federal witness tampering statute Lindell cited only applies to federal official proceedings. And Lindell, they said, failed to identify any qualifying federal proceeding that was allegedly tampered with. Wrong statute, wrong type of proceeding.
Again, very precise legal requirements.
Yeah.
And mail fraud.
Similar issue. Dominion argued Lindell didn't claim the supposed RIO enterprise tried to get any actual property from him through fraud. And they also argued that simply filing and pursuing an ongoing lawsuit generally doesn't count as a mail fraud predicate act under the law.
Man, it's like legal chess, hitting every specific requirement. So Dominion is essentially saying, look, even if you believe Lindell's narrative, the actions he describes don't legally satisfy the strict definitions needed to prove RICO, not based on these predicate acts or the enterprise structure.
That's exactly their argument. The conduct alleged, they contend, just doesn't map onto the precise statutory requirements for these very complex claims.
All right, let's shift to the constitutional claims. The ones under Section 1983. These are serious, alleging violations of fundamental rights like free speech or equal protection. What's the absolute bedrock requirement for any Section 1983 claim?
The fundamental hurdle, the absolute core requirement for all Section 1983 claims is demonstrating state action.
State action, meaning?
Meaning the alleged violation of constitutional rights had to be committed by someone acting under color of state law. Essentially, the government, or someone acting like the government, has to be involved in the violation.
And Dominion's argument was?
They argued very strongly that Lindell and MyPillow completely failed to plausibly allege that Dominion, or Smartmatic, or the PR firm were acting as state actors when they did the things Lindell complained about, filing lawsuits, sending letters, talking to the media.
What does acting under color of state law actually mean, though, especially for a private company? How do you figure that out?
It's the same standard courts use for state action under the 14th Amendment. It applies when a constitutional right is violated because of some power or privilege granted by the government, or because the entity doing the violating may fairly be said to be a state actor. It's not always clear-cut with private companies.
So just because Dominion provides voting equipment to states doesn't automatically make everything Dominion does qualify as state action.
According to Dominion's argument in these filings, no, absolutely not. They contended that while providing equipment makes them government contractors, it doesn't magically transform them into state actors for every single thing they do.
The focus has to be narrower.
It's exactly. State action analysis, they argued, must focus on the specific conduct being challenged. Here, the challenged conduct was filing lawsuits, sending cease and desist letters, talking to the press. Dominion argued these are private company actions, not things they were doing as agents of the state operating the election itself.
What about the argument that running elections, or parts of them, is something only the government traditionally does? Does that make Dominion a state actor?
That's touching on the exclusive public function theory. Dominion addressed that too. They argued this theory doesn't apply because for a private entity's actions to count as state action under this specific theory, the function has to be something the government has traditionally and exclusively performed.
And providing voting machines doesn't count.
They argued no. Providing voting equipment or related services, they contended, isn't something the government has exclusively done. Historically, private companies have been involved in various aspects, like printing ballots or providing the machines themselves, so it doesn't meet that high exclusive public function bar.
Okay. Lindell also brought an equal protection claim, right? Saying Dominion treated him unfairly compared to others, like not suing left-leaning people.
Yes, and Dominion's response there was that the equal protection claim failed because Lindell didn't identify anyone else who was actually similarly situated to him.
Meaning?
Meaning someone who made the same kind of specific, provably false statements about Dominion, with the same alleged high level of intent, what the law calls actual malice, that Lindell himself is accused of making.
So general criticism isn't the same as specific allegations of fraud.
That was Dominion's point. The sources, quote, some of Lindell's very specific claims machines built to cheat, algorithms fuzzing votes. Dominion argued these were inherently improbable, factually specific claims, fundamentally different from perhaps more general commentary others might have made. Equal protection requires comparing apples to apples, essentially.
And the substantive due process claims. That sounds quite broad. What's the standard for those?
The legal standard for violating substantive due process, especially through private conduct alleged to be state action, is incredibly high. It's often called the shock the conscience standard.
Shock the conscience?
Yeah. The conduct must be so egregious, so outrageous, that it may fairly be said to shock the contemporary conscience. Dominion basically argued that filing a lawsuit, sending warning letters, or talking about a lawsuit in the media, even if you disagree with it, simply does not come anywhere close to meeting this extremely high threshold. It's usually reserved for truly shocking abuses of governmental power.
Okay, so that covers the constitutional claims.
Yeah.
Let's move to MyPillow's claim for tortious interference with prospective economic advantage. This is about messing up potential business deals, right?
The gist of it, yeah. Someone wrongly interfering with your expected business relationships.
What did MyPillow need to prove for that, and what did Dominion say was missing?
Okay, so the sources indicate Minnesota law applied to MyPillow's specific claim here, since MyPillow is based in Minnesota.
And under Minnesota law?
This type of tort requires showing that the intentional interference was somehow independently tortious, meaning the act of interfering was itself based on some other illegal or wrongful act, like defamation or fraud, or that it violated a specific statute.
So just interfering isn't enough. The interference has to be wrongful in itself.
Exactly. Dominion argued MyPillow failed to identify any such independently unlawful conduct by Dominion, Smartmatic, or the PR firm. They argued the actions taken, like Dominion filing his lawsuit or making public statements about it, weren't independently illegal acts that could support this tortious interference claim.
Was there another requirement mentioned for this claim under Minnesota law?
Yes, there was. MyPillow, as the plaintiff making the claim, needed to identify a specific third party, like a particular retailer or business partner, with whom they had a probable future business relationship that was actually interfered with by the defendant's actions.
And Dominion said?
Dominion argued that MyPillow failed to do this in their legal filings. Even though Lindell had spoken publicly about retailers dropping MyPillow products, the legal claim itself apparently needed to name the specific third-party relationships affected, which Dominion argued it didn't do sufficiently.
So lacking specifics again. Finally, the civil conspiracy claim. Lindell and MyPillow alleged these companies all conspired together. What was Dominion's counter-argument?
Dominion argued that Generally, in the relevant jurisdictions, civil conspiracy isn't really a standalone claim you can sue for all by itself.
It needs something else.
Usually, yes.
Yeah.
It's typically seen as a way to hold someone legally responsible for an underlying tort committed by someone else in the conspiracy. So you'd prove they conspired to commit, say, defamation, or conspired to commit tortious interference.
And Dominion's point was?
That since Lindell and MyPillow failed to adequately allege any underlying illegal act that these parties could have conspired to commit since the other tort claims failed, then the conspiracy claim had to fail too. No underlying wrong, no conspiracy claim.
Kind of like dominoes. If the first claims fall, the conspiracy claim falls with them.
That's often how it works, yes. Plus, similar to the RICO enterprise point we discussed earlier, Dominion also argued Lindell and MyPillow failed to plausibly allege an actual agreement, a meeting of the minds, between Dominion, Smartmatic, and Hamilton Place Strategies to commit any wrongful acts.
Just saying they acted similarly wasn't enough.
Right. They claimed the allegations were too vague, too conclusory, or only pointed to actions that might look similar, parallel conduct, but didn't actually show proof they secretly agreed to act together for an illegal purpose.
It's incredible just how detailed and specific the legal system requires you to be. You really have to check every single box for each type of claim.
It really is fascinating. You see the courts being asked to apply these established, often very precise legal tests developed over decades, to claims arising from this incredibly contentious, high-profile political situation. It highlights the system's reliance on these defined standards, even in heated circumstances.
And if we connect this back to the bigger picture, especially defamation law, the sources touch on that First Amendment background, right? Cases like New York Times v. Sullivan.
They do. That landmark case Sullivan is crucial. It established the high bar for public figures, or on matters of public concern needing to prove actual malice.
Meaning knowledge of falsity or reckless disregard for the truth.
Exactly. Proven by clear and convincing evidence, a higher standard than the usual preponderance of the evidence in civil cases. It's meant to protect robust public debate.
But, and this seems key, the sources also emphasize that while opinions in debate are protected, outright false statements of fact generally are not protected speech.
That's the critical distinction the law tries to make. The legal system, through cases exactly like these, is constantly trying to navigate that difficult line, holding people accountable for provably false factual claims that cause real harm.
While also trying not to chill legitimate speech or the right to raise legal concerns, even controversial ones.
So if we tie this all together, what this deep dive really shows us is how the courts handle these serious counter-allegations claims of lawfare, for instance. They do it by rigorously applying specific, often quite narrow legal requirements for each distinct type of claim.
You have to show actual use of process for abuse of process, specific state action for constitutional claims, the defined predicate acts, and enterprise structure for RICO.
Exactly. The plaintiffs making these counterclaims have to meet those specific burdens of proof.
It really underscores the complexity here. Navigating these disputes means getting deep into statutes, case law, and precisely matching the alleged facts to the required legal elements, all while trying to balance fundamental rights, the right to sue versus the right to speak.
It definitely raises a thought-provoking question as we wrap up. Thinking about how the legal system approaches this, based on what we've seen in the sources, how does the very high bar the system sets for claims like abuse of process or for finding state action, by demanding such specific proof, how does that attempt to balance?
Balance what exactly?
Balance someone's fundamental right to access the courts, to seek redress for what they see as wrongs, against another person's right to criticize, to make allegations, or even just to speak forcefully on contentious public issues like the integrity of an election. It's a delicate balance the courts are constantly trying to strike. Something for you, the listener, to consider as these kinds of cases continue to play out.